Welcome, everybody. Welcome to this series of webinars that we organized at Moncton Chambers in order to discuss the legal issues raised by the UK-EU Trade and Cooperation Agreement. I have a few seconds for all our participants to join us. I am Panos Koutrakos, and today in this second webinar in our series, we discuss one of the most controversial and some might say innovative features of the agreement, subsidies and subsidy control. Some housekeeping before we start. The webinar will last for 45 minutes. I would be grateful if you typed any questions you might have in the Q&A. I shall read them out and ask our panelists to address them. We may not be able to answer all your questions, for which I apologize in advance, but we shall do our best. Now we have a stellar panel of Moncton barristers with us to examine the mechanism introduced by the agreement. We have Annalie Howard QC, George Peretz QC, Alan Bates, and Ben Raymond. We find the mechanism for subsidy control in heading 1 of part 2, which is about trade, entitled 11, which is about level playing field, in chapter 3. I should like to start from the terms in which the relevant rules are being couched. We notice that the term state aids, with which we have been familiar for so long, is not being used any longer. Annalie, should we read too much into this?
Well, it's interesting when you look at the panoply of legislation that will now cover state aids, that there have been two major shifts. One is obviously in the terms of the lexicon. And if you look at the terms of the TCA at the moment, there is no reference to state aid in there as we know it. So in fact, we've got a new fines box that's going to be in place. If anyone starts referring to any previous concepts of state aid as we knew it, you'll immediately be hung up because you now have to refer to subsidy control. You can't refer to undertakings, you have to refer to economic actors. You can't talk about aids being selective anymore, you have to talk about them being specific. So there's been a linguistic shift away from the familiar terms that we are aware of. But obviously, when you actually go through the provisions of the TCA, the actual underlying concepts seem strangely familiar. And although we're not necessarily going to have all of the Commission guidance and staff working papers and communications that obviously aided our interpretation and application of the EU state aid regime, that's all been done away with because of the state aid EU exit regulations that came into force at the end of last year, which have now made it clear that all the provisions that were in Article 107 and 108 of the treaty are no longer carried across and will no longer have effect as EU retained law. So we're going to have our own domestic regime. Obviously, the terminology is going to be different, and we'll have to wait to see exactly what is going to be covered. The other element I think we also need to be aware of is obviously the TCA is just one trade agreement, and that fits within the wider global jigsaw. And one stunning thing that comes out of the guidance that the CMA has issued on state aid is obviously when you're looking at any grants or subsidies or loans, you can't just look at it under the terms of the TCA. You've got to take a wider lens and think, well, hang on, how does this fit? Not just under the TCA, but under the WTO. Also, the UK has entered into and is entering into up to 40 continuity FTAs with various countries around the globe, which also have their subsidy provisions. And then there is also the prospect of the UK's potential entry into the CPTPC with 11 Pacific members and New Zealand and Australia, and possibly, who knows, the US as well. So you can't just assess this directly under the TCA, and you do need to be aware that there are slight differences between all those various international agreements. So the TCA, for example, covers goods and services, but the WTO only covers goods only. and there are differing approaches in the various other FTAs.
Thank you, Annelie. We may come back to this international dimension, which is quite interesting. But you mentioned the underlying principles we find in the agreement. Alan, would you please summarize the main substantive principles that govern the new regime?
Wow, that's a big question, Panos. There's obviously a huge amount that can be said about the TCA subsidy control rules, but I suggest there's four key things to know. The first is that the UK has to have an effective system of subsidy control that ensures that subsidies are granted only where they pursue a specific public policy objective and are proportionate for that purpose, and that subsidies shouldn't normally compensate beneficiaries for costs they would have had to bear anyway as a cost of doing business. So the principles are similar to those applied by the Commission when deciding whether or not to authorise state aid. The second key thing to know is that there's no requirement for ex ante control. So state aid controls at the moment anyway in the UK is effectively by operation of Section 29 of the Future Relationship Act, which effectively gives the relevant provisions of the TCA direct effect in UK law. And there's no way at present, at least, to obtain prior approval for aid, whether from the CMA or any other body. And strictly speaking, the Commission's block exemptions don't apply either. So UK public authorities can effectively authorise their own subsidies by considering whether they're proportionate, etc. Now that may change when the UK develops its own subsidy control regime, but at present, as Annelie said, that doesn't exist. The third thing to know is that there are some forms of subsidies that are simply prohibited. For example, aids in the form of unlimited guarantees and subsidies for rescue and restructuring where they're not based on a credible restructuring plan. So those are some examples of prohibitions that go beyond the specific prohibitions in the WTO rules. And then the fourth thing to know is that enforcement is available through the domestic courts, which can make orders that subsidies be repaid by the beneficiaries.
Thank you, Alan. The agreement refers specifically to services of general economic interest. Annelie, would you remind us what the position is in the new regime?
Thanks, Panos. Yes, I will. Now, the element of public service contracts and government procurement, so entities that have special statutory monopolies or special rights and privileges or are carrying out public services, are of huge interest internationally. Obviously, while we're negotiating these international agreements with other countries, foreign operators are also very keen on these opportunities. Obviously, the US is intensely interested in the NHS, but there are also these special rights that are given whether you're running trains, whether you're operating water, in the water or energy industries. These heavily regulated infrastructure industries are obviously of huge interest because of the exclusive rights that are given, which gives you an automatically a powerful position in the market. There are issues about compensation, your ability to earn a monopoly revenues, but there are also possible spillover effects into other related markets and the risk of cross subsidiaries and leveraging. So this is a often overlooked but very important sector of the market. Now, under the treaty, the TFEU, obviously there were the provisions in Article 106, which set out a prohibition on the government creating national monopolies or measures that would be contrary to important rules such as competition law, state aid, or public procurement. But there was a carve out in 106.2 for services of general economic interest. That's where there's a distributive or some kind of economic efficiency that's generated by creating a special entity able to deliver these services. And also services in the general interest, so those that might be pursuing not something that's economically efficient, but may be justified from a wider social justification, such as environmental concerns or social diversity issues. So there was an allowance that competition law could be limited insofar as it was necessary for the entity to perform those tasks. Now, interestingly, Article 106 has not been knocked out under the regulation I was talking about earlier, so it will carry across as EU retained law. But a lot of the guidance that the Commission issued about services of general economic interest is soft law, so that will not qualify as EU retained law. But within the TCA, there are specific provisions, both for statutory monopolies, which we now have to refer to as covered entities. That's in Article 4 of the TCA, which covers any state-owned enterprise where the state owns more than 15%, or where there's special rights and privilege that have been granted. And there are specific obligations that apply where this entity carries out commercial activities. And that's to prevent there being a distortion of competition in markets where the state-sponsored entity is competing with other commercial entities, both in the UK, but also obviously with entities from the EU. And the most crucial point is that there is an obligation in Article 4.5 that this entity is not allowed to discriminate against EU goods and services, and it is not allowed to favour domestic goods and services supplied in the UK. And it must carry out all its decision making on market economy principles. So it's not allowed to cross-subsidize or to distort its decision-making process. So that carries across the spirit of Article 106.1, but obviously it's in much broader terms, and we don't have the necessary underpinning of what those concepts actually mean and how they're going to be applied in practice. For the second element of 106.2, that was specifically for services of general economic interest, there is a special provision in Article 3.3 that also allows the government to set up designated entities that carry out tasks in the public interest. Obviously, that's not just economic, it will cover social services as well. And that's probably quite key to the government's policy of levelling up and making sure that it tries to overcome regional differences. It must make sure that the award of any public service contract is subject to certain principles. So it has to address specific market failures or social difficulties. The level of the subsidy must be proportionate and must not go above the reasonable costs of providing the service with a reasonable profit margin. And there must be an appropriate means to deliver these services. So there's no other way of delivering them. So there's a list of about 8 different criteria that must be met, and including transparency obligations, but it is nowhere near as detailed as the very complex regime that's applied under the Altmark process and under the Commission's guidance and communications on services of general economic interest. And obviously we'll have to wait to see how the UK develops its own regime. I mean, this was a fiendishly difficult area, and it was one of those areas where you have to put a cold towel on your head and look at 5 different documents simultaneously to tease out all the various criteria and thresholds and monitoring obligations that the Commission imposed. So I think there is an opportunity here to simplify the regime, but obviously we'll have to wait to see exactly what the UK is going to do.
Thank you, Annalie. Let us now talk about enforcement. Ben, which role does the new system envisage for domestic courts?
Well, thanks very much, Panos, and hello, everyone. The TCA doesn't impose any obligation to create a new court or tribunal, so it's the administrative court for now that's going to be effectively the sole enforcer of this new regime in the absence of the independent authority being set up. Obviously, the courts must be able to comply, to review compliance of decisions by granting authorities or the independent authority when that's established, in accordance with the Article 3.4 principles that Alan has been explaining. It's going to be ordinary judicial review standard. So that means that obviously in relation to questions of economic assessment, the decision maker will be afforded a margin of discretion, but I think we can still expect quite rigorous scrutiny on levels of reasoning, and also in relation to some of the legal concepts in the new terminology that others have been referring to. What about standing requirements under this new regime? The TCA actually imposes some specific rules here. It allows for wide rights of challenge by competitors, trade associations, and indeed any person whose interests might be affected. So it certainly looks to me as if it's as wide as our own domestic sufficient interest test under the civil procedure rules. And I think organisations like pressure groups will probably be able to challenge under these wide rules. The EU and the UK themselves have retained automatic rights to intervene in these other courts in relation to these challenges. Remedies, obviously, is a crucial area when we're discussing the courts. The TCA says there must be effective remedies for breaches of domestic law. Remedies of prohibition, suspension, damages, and recovery are all referred to. But those requirements to insert those or to implement those remedies are subject to two qualifications. First, remedies are only required if the remedies were available on the entry into force of the TCA. But on the UK side, you don't count any remedy that was only available as a result of the European Communities Act 1972. So that suggests that the damages remedy may not be available in the UK because arguably that was only available previously as a matter of EU law. And then secondly, although the general principle is you keep your existing remedies, there is a requirement to create a new remedy of recovery of subsidies unlawfully granted, which for the time being will be the role of the courts. And then finally, what about limitation rules? The TCA modifies domestic limitation rules, and of course that's absolutely crucial because in a new world where people are looking for grantors and recipients are looking for some degree of safety, you know, the expiry of a limitation period means that promises you some safety in terms of risk of challenge. The new rules are quite interesting. The basic time limit is 1 month from the publication of certain basic information about the subsidy that's been granted. The basic information has to be published within 6 months of the grant on an official website, which I understand is still under construction. So that's an immediate problem at the moment. Let's hope it's up and running within 6 months. In tax measures cases, there's actually a longer period to publish the basic information. And then after that, interested parties have a right to ask for fuller information regarding the basis of the subsidy. So that's when you have to, if you're a grantor, deploy your sort of full reasoning and justification for the subsidy. And the effect of receiving such a request is to extend the limitation period by a further month, and from the provision of the further information that interested parties are entitled to. And I think an issue is that obviously if publication is not made on the official website, for example, because something was not thought to be a subsidy, you have the problem that, you know, there's a subsidy out there that's open to challenge for potentially an extremely long period of time indeed. And also another interesting point, I think, is the interrelationship of the TCA rules on limitation with other limitation rules. And I think one area that may need some attention is the limitation, how it interacts with the limitation rules in relation to public procurement, because public procurement decisions are subject to a specific set of limitation rules, but they often involve decisions that could involve the grant of a subsidy. So there may need to be some consideration of how these rules interrelate there. And then finally, obviously, we've had the technical guidance issue, but it really doesn't say anything useful about courts. It simply says, it simply warns grantors that to be mindful that what they do now could be subject to challenges in the courts, and that Her Majesty's government may in due course provide some more clarity about the role of the courts. But until that is provided, we are where we are. Thanks very much.
Thank you, Ben. As we know, the TCA is but a part of the evolving legal framework that governs our relationship with the EU, and some parts of it have yet to materialize. The agreement itself refers to supplementary agreements, and there are various arrangements pending in different areas. But an important part is already in force, and I'm talking, of course, about the withdrawal agreement and the Northern Ireland Protocol. George, what issues does the new subsidy control regime raise for Northern Ireland?
Yeah, well, people, and there probably were some people who supported Brexit because they had objections to the state aid regime, might be slightly disconcerted that the result we now seem to have is that we now have, instead of one state aid regime, we have two. One in the Trade and Cooperation Agreement and one in the Protocol. As I'm sure a lot of people listening already know, Article 10 of the Northern Ireland Protocol applies EU state aid law to any UK measure, so in principle the act of any UK public authority, but confines that application to measures that have an effect on trade between Northern Ireland and the EU in the area of goods. Now there's a bit of a dispute as to whether effect on trade has to be read in the same way as the Commission and the Court of Justice have always read that provision in the context of EU law, though some suggestion around that it should be read differently. The Commission notice published on the 18th of January says very firmly that the concept is to be read in the light of the same notion in Article 107.1 of the treaty, but that might be said simply to be the Commission's view, although of course the Commission is under Article 12 of the Protocol, is the enforcer of that provision in the same way as it enforces state aid law in member states. So its view might be certainly worth noting. There is guidance issued by BEIS, the guidance issued on the 30th of December. In fact, that guidance is statutory guidance under Section 48 of the Internal Market Act that requires there to be guidance. Not entirely clear. It's clear that section says that public authorities, those with functions under in relation to the grant of subsidy, have to take account of that guidance or have regard to that guidance. Not entirely clear whether that includes courts, but it would certainly include granting authorities. So that there is that BEIS guidance. The BEIS guidance, however, it doesn't comment on the directly on whether effect on trade is to be read in the same way as we're familiar with reading it in the state aid law context. But what it does say, purporting to cite declarations by the EU and noted by the UK in relation to the protocol, it states that in BEIS's view, the article will not bite unless there is a direct relationship between the aid and, quotes, companies in Northern Ireland. Now, that, in my view, is quite a gloss, certainly on what effect on trade is likely to mean if you apply EU law to that concept, but also on what the declaration actually says. Because the BEIS guidance seems to suggest that unless you can point to a company that is actually in Northern Ireland, which tends to indicate that it's a Northern Ireland company, then you don't need to worry about Article 10. That seems to me to be over robust. The Commission guidance, on the other hand, expressly gives examples of where Article 10 may apply in relation to companies that simply trade with Northern Ireland or have goods on sale in Northern Ireland. And that, I suppose, is an extension of the way in which the Commission would approach a probably slightly hypothetical, but nonetheless possible example of a member state that granted aid to a company that happened to be located outside the EU. The state aid rules would apply to that grant to the extent that it had effect within the EU. And I suspect the Commission's starting point is much the same. The UK any UK measure that affects trade between Northern Ireland and the EU is simply to be regarded as caught by Article 10. So the position is a bit unclear. It's also going to be practically quite tricky for authorities that feel that there is a risk, or beneficiaries or funders who feel that there is a risk here. Because if they are advised that there is a significant risk that Article 10 applies and it doesn't fit within any of the block exemptions, what do you do? Well, the only answer is to go to BEIS and try to persuade them to notify. I mean, the problem there is going to be that the political pressure on BEIS not to notify is obviously going to be pretty immense, and particularly in a case which isn't obviously centred on Northern Ireland. So that may end up leaving funders and authorities and beneficiaries in some doubt in cases where there is a significant risk of the protocol applying as to what to do in a situation where BEIS says, no, we refuse to notify because we refuse to accept that there is a sufficient effect here for notification to be appropriate.
Thank you, George. I mean, very briefly, one of the questions we got about Northern Ireland is about whether the concept of indirect aid might help when thinking about the scope of the protocol, whether, in other words, there are companies engaged in EU Northern Ireland trade that could be said to be indirect aid beneficiaries. Do you think there is anything to say about it?
Well, again, there's a bit of a conflict between the BEIS guidance and what the Commission says, because the BEIS guidance constantly talks about direct effect, whereas the Commission guidance uses indirect every time it uses direct. And not only that, but gives some examples, some quite striking examples of where it thinks the protocol might apply. For example, to a financial services company that has clients in Northern Ireland that supply goods. So a really indirect effect. And there's the Commission saying, oh, well, in this case, you might well have an application of Article 10. So there is a real conflict of guidance here. And any court looking at this is going to have to consider both, I think. I mean, the Commission guidance, at least arguably, has the same status that Commission guidance would while we were in the EU, particularly as the Commission is the enforcer and has enforcement powers. The BEIS guidance has statutory force, has to have in relation to public authorities, and arguably has to be looked at by courts as well. What do you do when they conflict? Well, that's going to be an interesting question.
Thank you, George. Dispute settlement was one of the most controversial issues in the process of negotiation of the agreement. Alan, what does the agreement provide for the settlement of disputes between the UK and the EU?
Yes, an interesting feature of the provisions of the TCA about dispute resolution in relation to subsidy control is that the general dispute resolution provisions in the TCA have been considered insufficient. And so you have some special options that apply. The main one is the possibility of remedial measures. And this arises where one party believes that a subsidy causes, or there's a serious risk it will cause, a significant negative effect on trade or investment between the parties. And what the party who fears that can do is essentially to give notice to the other party. There's then a period of consultation that lasts 60 days. But if at the end of it, the party that feels aggrieved considers that it has reliable evidence of harm to identifiable goods, services, or economic actors, it can then unilaterally impose its own remedial measures, provided that the measures it imposes are proportionate. There's a possibility for arbitration, but importantly, arbitration doesn't have suspensive effect on the remedial measures from being adopted. So that's the main state-to-state enforcement mechanism, if you like. Something that could also be relevant here is something called rebalancing measures. And these apply where you have subsidies in the labour, environmental or social field that are consistent with the TCA's provision, but where there are significant divergences between the UK and EU with regard to subsidy control that are considered by one party to impact negatively on trade or investment. And in those circumstances, there's a possibility for the aggrieved party to adopt its own rebalancing measures. Again, there's an arbitration process that can be engaged to assess that.
Thank you. We talked earlier about enforcement, and of course the agreement provides for the establishment of an independent authority and encourages the cooperation between the authorities established by the parties. George, would you say something about this? I mean, have we seen any development in this area?
Sorry, I was looking rather at somebody's question. What was the question again?
The question was about the independent authority, the
Yes.
establishment of which is provided in the agreement, which also encourages the cooperation between the independent authorities of the parties.
Yeah, well, the independent authority it's a requirement to set one up under the Trade and Cooperation Agreement, and it's got to have an appropriate role, which is not exactly enlightening as to what that is. I mean, I think people will have picked up from the discussion a number of things that an independent authority could, I think, on any view, and however much the government wants to move away from the state aid rules, usefully do. One thing it could usefully do would be to issue safe harbour block exemptions, so that there would be cases where public authorities just need not even think about, do the sort of effort, go through the thinking, not even go through the thinking process that the guidance asks them to go through, in cases where boxes can simply be checked, and it's decided that any subsidy falling within those provisions is simply not capable of falling within the subsidy provisions. That will be quite useful. And those provisions could be much less constraining and artificial than the EU block exemption regulations, which have the rigid structure that they have, largely because they're trying to apply common rules across 27 member states, which is obviously not so much of an issue for the UK. One can perhaps go rather further in many respects than the EU block exemptions do, without there being any real risk of allowing through subsidies that could adversely affect trade or investment in relation to the EU or anyone else in a significant way. So that's one obvious function of an authority. The authority could also be charged with the role of issuing guidance, and that would again be as to how to apply the principles. That would, you could make that guidance to which courts as well as authorities would have to have regard, and that would, I suspect, be welcomed by the courts, who I think are going to appreciate as much guidance as they can have in approaching what will be quite a new task for them. The independent authority could also, without replicating the sort of central feature of the EU state aid law system, that if you don't notify ex ante, then your subsidy, no matter how wonderful it is void and has to be recovered. You don't need to replicate that, but you could still give the independent authority some form of ex ante power, even if it's voluntary. You could have a regime which allowed public authorities and beneficiaries to go to the independent authority and get its blessing in the form of a decision if they thought that that was important. And of course, the effect of that would be to insulate themselves against subsequent challenge in court, the same effect as a clearance decision. And anyone who was unhappy with the independent authority's decision would then have to challenge that in court. Just as at the moment you have to, if you are unhappy with the clearance decision by the Commission, you have to challenge that in the General Court. So I mean, I think there's lots that an independent authority can do without necessarily giving it the essential gatekeeper role that the Commission has. I mean, one issue that will need to be explored is the balance between policy making and application of policy. The May government, when it was outlining a domestic state aid regime for the UK, gave BEIS the role of formulating policy and the CMA the role of essentially applying it. Quite how that's done here, I think, will be quite interesting and important.
Thank you, George. I think we now have a good overview of what the new mechanism aims to achieve, how it would go about it, and what the main issues are in its application. Before we move on, let's pause for a second, take a couple of questions. Anneli, would you briefly tell us about a failure to have evidence supporting compliance with the main principles, and what effect this would have on whether the decision may be regarded as having been made reasonably by the courts?
I mean, obviously the authority is going to have to provide whether, I mean, we don't know what the exact standard and the route, whether it's going to be JR or whether it's going to be appeal on the merits yet. I presume it's going to would be with the trend towards JR, there's going to be a judicial review standard for the authority's decision making. But it's quite interesting that the level of deference, particularly on reasoning in ordinary JR cases, is being under intense scrutiny. I mean, last year in the rail franchising litigation, there was pretty painful examination, not just of the evidence that was underpinning the decision, but also the decision-making chain and the actual reasons that underpinned the final decision. And the court was very, very clear that it expects detailed reasoning by the decision maker. So it's not just enough to present a package of ministerial submissions and say, well, these were the considerations that were taken into account in reaching the decision. The court actually wanted to know what did the decision maker have in mind at that time, and where's the documents that show us what the decision maker had in mind. So the paper trail is incredibly important. Now, you may say that's under the procurement regime, that was in the TCC, that's very different to the approach that would be taken under standard JR before the admin courts. But even in that sphere, the courts are becoming more, showing closer scrutiny of the underlying evidence and the reasons for the decision. So I think whatever decisions are taken, they will need to be packed and supported by a very credible evidence base and a clear paper trail of the decision-making process.
Thank you, Annelie. Let us now step back a bit. Let us assume that there is a company which has been the recipient of a subsidy. What does it have to worry about, really? And similarly, what about the grantor of a subsidy? What is it that they must worry about? Ben? Ben, would you unmute yourself, please?
Sorry, again, staring at the chat function. Yeah, so I mean, obviously for grantors, they are in is culturally a different regime where you are now much more on the front line, in the sense that it is you are taking the decision. It's not something that you're just sort of notifying to somebody else for a decision. You actually have to own the decision, and I think that is quite challenging as things stand at the moment. Obviously, depending on how the role of the independent authority is established, will impact on that. But I certainly think that's a big issue for grantors now. They just have a lot more responsibility and ownership of these decisions, and where you are. It is different where you are sort of sponsoring something and providing supporting reasons in favour, as opposed to where you really have to be pretty sure as to whether this is going to pass muster or not. That is a different function, as we all know, on the grantor side. And I think as far as recipients are concerned, obviously they are going to be concerned about the potential for recovery challenges. They are going to be worried about the point that I think has been raised in some of the comments on the chat function, which is that, for example, how high is the effect on trade and investment hurdle going to be? Because in those borderline cases, if the subsidy is not brought to sort of public attention, as it were, then you have a risk of a challenge and the potential for recovery hanging over you for quite some time. And I think what we may see is the development. It depends how the architecture of the new sort of transparency system and official websites develop. But I think we may see procedures being borrowed from areas like procurement, where people make voluntary disclosure notices of things that they've done in order to flush out a challenge, because they see that as the only way of developing. Of getting sufficient certainty. The new regime does present opportunities, and one shouldn't be just negative about it, but unfortunately with the new freedoms and the new opportunities, if you want to characterize them like that, and as I've heard people describe them, the downside is there's also more uncertainty. So people need to think very carefully about how they're going to insulate themselves, and as I say, drawing out, putting enough information into the public domain to then insulate yourself, to know that after the limitation period has expired, you're safe, is going to be potentially quite important.
Thank you. Let us zoom in for a moment in the UK. Let us think from the perspective of a UK company, which feels that a competitor also in the UK has been granted a subsidy, or they want a tax break, which their UK competitor has got. What can they do about it under the new regime? Alan?
Well, I think the first thing I would look at if advising the prospective challenger would be the Northern Ireland Protocol, because if the aid recipient is engaged in any trade in goods between Northern Ireland and the EU, then you may be able to rely on the state aid rules anyway for bringing your challenge, whether by complaining to the Commission or bringing action in the domestic courts. But if you can't rely on the Northern Ireland Protocol, then even under the TCA regime, there are opportunities for domestic enforcement, even by a UK-based company in relation to an aid granted to another another UK company. And the reason for that is because, as we've already discussed, unlike with many of the provisions of the TCA, where the mechanism for enforcement is only state to state, there is direct enforcement in the UK courts in relation to the subsidy control provisions. There are specific transparency requirements that have to be complied with by UK authorities when they're granting subsidies that require publication of information about the grant of the subsidy within 6 months. Anyone who has who's an interested party, and that's a term that's defined in quite broad terms in Article 3.76 as being any natural legal person whose interest might be affected by the granting of the subsidy. So any such person can then seek further information with a view to deciding whether or not to bring a challenge. That information has to be provided by the public authority within 28 days. And then after that, the challenger has a month after receiving the information to then bring a challenge by way of judicial review. And the test for whether or not you can bring that challenge again will be the interest test under Article 3.7, which I think in practice will be applied by the administrative court as meaning much the same as a sufficient interest test in judicial review. So there's certainly plenty of scope for UK on UK company challenges to subsidies of that kind.
Thank you, Alan. And let us now turn things around. Let us think from this perspective of an EU company. What if they are not happy that their UK competitor has been granted what they consider to be a subsidy? What is it that they can do? Annalie?
Well, I think there's 3 main routes, rather similar to Alan said. So first of all, I think I would first check under the Northern Ireland Protocol, if only because litigation, you've always got the legal risk and the cost benefit of litigation. And obviously the familiarity of the EU regime provides that legal certainty, which is going to lower your risk profile. So if you can show that there is an effect on EU trade because of Northern Ireland, I think that is your first port of call. If not, if it's concerning England, Wales or Scotland, then I think you've got 2 routes. One is the public enforcement route. And obviously that's lower cost, but it's state to state dispute resolution. So you there is immediate loss of control. You would make your complaint to the Commission or to your own government and ask them to invoke the dispute resolution provisions in the TCA. But obviously you have no direct role in that, even though you might be a competitor that's been excluded from the market. What extent, this is an interesting question, can the private party shape and influence that process? Because obviously the dispute resolution provisions can only be triggered on the basis of credible evidence. It's very explicit throughout the TCA that they can't be started purely on the basis of conjecture. So I think your chances of getting a referral or a request for conciliation or for rebalancing will only arise if you can really pack your complaint with credible evidence on the building blocks of the breach that you're trying to show. So showing that there has been some economic advantage, that this is a specific subsidy that's been given to one undertaking, and most importantly, the effect on the trade and investment. Because if you can show there's a material effect on trade or investment, you then get into the rebalancing measures regime in Article 9.4 of the TCA, and that is a fast track process. So although there's an element of conciliation, it's over a much shorter time frame, and there is the possibility for for measures to be taken in quick response by the EU. So that's one area. The other area, I think, is when you look through all the provisions of the dispute settlement process, there are opportunities for consultation, whether that's through interested parties, through domestic agencies, through panels of experts, and there may be a way for private entities to have some role in that process indirectly. But obviously, if you want a quick remedy and you want to stop the grant or to try and set it aside, then you're really looking at private enforcement. Obviously, an EU entity that has been excluded from a grant, a special grant, or has been adversely affected through a distortion of competition, would have a direct right of action in the UK courts to challenge the grant under Section 29 of the TCA by bringing national litigation. And you would say that it was either both in breach of the UK regime or the provisions of the TCA.
Thank you, Annalie. I'm afraid our time is up. There were many questions from our audience. We're sorry that we're not able to answer all of them. There were too many questions and our time was limited. In some ways, the number of questions followed the pattern that we see from the application of the new subsidy control mechanism. Too many questions. We hope we will be able to answer more questions and hopefully deal with answers provided in the questions we've already examined later on in the year. In the meantime, I would like to thank very much my Moncton colleagues, Annalie Howard, George Perrett, Alan Bates, and Ben Raymond, and thank you very much.